The biggest detriment to Chapter 11 is that it's extremely expensive. It's a very cumbersome prospect. Unfortunately, when Congress created Chapter 11 in 1978, became law in 1979, Congress did not distinguish between Lehman Brothers or an individual in Chapter 11. So the individual really has to jump all the same hoops.
Yuck.
As I look at the three types of bankruptcies for individuals, and getting to your question of which is best or which is most advantageous, what's interesting and kind of backwards from what you might assume is that if an individual files Chapter 7, the first type of bankruptcy, just to be relieved of debt, the process of Chapter 7 from the time of filing till the end of the Chapter 7 usually is only about 3 months. It's actually a very fast proceeding. Whereas Chapter 13, the payment plan, is a 5-year plan.
Right.
So in terms of individuals getting on with their life, getting a fresh start, if they equally qualified for Chapter 7 or Chapter 13, I might be more inclined to recommend Chapter 7 because the client will complete the Chapter 7 much faster and be able to reestablish credit much faster as well.
Okay. Now, is Chapter 7 then the most common type of bankruptcy for individual?
Yes, it is.
Okay. All right. Now, I heard that those bankruptcy rules were changed in 2005 to basically to protect the credit card companies. So, were they changed? How were they changed? How does that affect an individual's eligibility for bankruptcy protection?
Well, the 2005 amendments to the Bankruptcy Code, first of all, are probably the singularly worst written statutes on the books. Very poorly written. They were written by lobbyists, lobbyists for the credit card industry. So we saw this tremendous change. Many of us feel it was a horrendous change, very politically inspired. And the change brilliantly occurred just at the brink of economic collapse. The purpose of the changes to the Bankruptcy Code were quite simply to make it more difficult for people to file bankruptcy. There are now tests, eligibility requirements as to who can file Chapter 7. There are limits as to who can file Chapter 7. There are limits as to who can file Chapter 13. And it was absolutely an effort to try to block the door of the bankruptcy courthouse for many individuals.
Ew. Okay.
For better or for worse, today, many people, though, are qualifying for bankruptcy because as stringent as the requirements are, unfortunately, due to the tremendous gap between income and expenses, where for so many people, expenses exceed income, and because of the tremendous amount of foreclosures and fallout from foreclosures, many Californians today are qualifying for bankruptcy who would not have qualified a couple of years ago.
Yeah, well, I've heard that like record numbers of people are filing, and when you hear this thing about how much tougher it is, and then you hear how many people are filing, you say, you know, this doesn't seem like what was supposed to happen. But I guess basically we're in an extreme situation.
It's very extreme, and not only have the numbers jumped so tremendously, but again, it's who's filing. It's no longer Aqualung. It's no longer the credit card crazies. It's my family and your neighbors. It's everybody, because the economic distress knows no borders. Everyone is touched by it.
So how is eligibility for bankruptcy determined?
Well, there are a couple of different ways. In terms of Chapter 7, for people who have mostly consumer debt might be a home mortgage plus credit card debt, they actually have to take a test. They have to take something called a means test, which crunches through income and expenses. You take income, you take expenses, you throw in some herbs, you put it in a blender, and mystically you determine whether the person qualifies or not. And it's just about that mystical. However, one kind of loophole to the 2005 law is that if the individual's debts are primarily business, then the individual does not have to be tested in order to qualify for Chapter 7. So that, for example, the client of mine who has invested in numerous pieces of real estate, and those real estate that real estate's now upside down and the client needs to get rid of the real estate. In those cases, typically, the real estate debt is business debt, and that debt will exceed the consumer debt. So those individuals really have a free pass into Chapter 7.
Okay. So let's see here. Why should you consult with a bankruptcy attorney before going ahead with a short sale?
Well, there are a couple of reasons. First of all, the great known about short sales is that they are sheer torture. They're one of the more masochistic things I think one can endeavor to do. And the big question I think that should be asked is, why are you doing a short sale? What do you think you're going to achieve from a short sale? Number one, very often lenders who may agree to the short sale do not agree to be fully satisfied by whatever they get out of the short sale. So they may still pursue the borrower for any unpaid balance. Again, especially true on a junior deed. The other issue to consider with short sale is the tax consequence. And I know you as a CPA are very well versed in this and are seeing a lot of this, but I'm seeing folks do short sales or walk away from houses without any understanding that in so doing, there may well be tax consequences. So that to the extent that in a short sale there is debt forgiveness, as you know, that creates a taxable event. The forgiveness of debt or the cancellation of debt is treated as income by the IRS. That is one of the few tax debts which is wiped out in bankruptcy. So I have clients who were at the brink of doing a short sale. The result of the short sale would have been disastrous from a tax standpoint. They instead stopped the short sale, filed Chapter 7 bankruptcy, were relieved of any of the bank debt as well as the tax debt.
So the key there is you need to be in bankruptcy before that cancellation happens, or so the cancellation is part of as the process of your bankruptcy. Whereas if it happened outside of bankruptcy, let's say that you had a short sale and then you went bankrupt, well, that federal tax liability isn't going to go away.
Well, actually it would.
Oh, would it?
Yes, the cancellation of debt is going to be eliminated as long as the bankruptcy filing is in the same tax year as the loss, then that'll be fine. But if one was going to go through the incredible pain and hassle of a short sale just to follow it up with a bankruptcy filing, I don't know why they would bother with the short sale to begin with.
Right. Now, also, though, of course, a lot of people, I've been told, that a reason for doing the short sale is basically to help your credit, that you can recover faster from a short sale than you can from like a bankruptcy or a foreclosure.
I think it's all relative, and I think the fact of the matter is that given the current economic environment, I think ultimately people are going to recover whether it's a short sale or a bankruptcy because so many Americans have been hit by this situation. I think it's true that for a real estate professional, trying to avoid a short sale certainly might be a way to go. But I think you have to look at the whole picture. You have to not only look at the real estate, you have to look at other indebtedness, credit card indebtedness, what the state of income is, in order to make an intelligent decision as to which way to go.
Okay. So if you're thinking of doing a short sale, before you go ahead,